Hello there, I'm Eric Anderson, Tempe City Attorney, and I put together this video. It's a short video on the open meeting law. The goal of this video is to help guide you as you serve the city in your capacity as mayor and city council. So we're going to go through some of the basics of the open meeting law in this video, and then there'll be other topics, more intensive training available at other times. So what is the open meeting law? The Open Meeting Law, or OML, as you may sometimes see it in short form, is the general policy of the state of Arizona that all public bodies must conduct their meetings in a manner that is open and transparent unless certain limited exceptions apply. A public body is a broad term and includes counties, cities, and towns, and even special districts such as Salt River Project. For mayor and council, it is important to remember that the OML applies to all boards and commissions of the city, as well as any formally established subcommittees of the city council. I want to focus on the legal definition of a subcommittee, as this can impact how you interact with your fellow city council members in your everyday dealings. Two council members talking to each other at random does not create a subcommittee. For a subcommittee, you need to have a formal action. Two things need to happen to have an official subcommittee. One, the subcommittee must be formally established by either the mayor designating the subcommittee or the council voting in an open meeting to establish a subcommittee. And two, the subcommittee must be established to make recommendations regarding a specific purpose, and those recommendations are recommendations to the entire body of the council. You will recall that the rules of procedure that were adopted by this council to govern its meetings and dealings provide specific procedures for establishing a subcommittee. When you follow those procedures, you will have a subcommittee that is legally defined in accordance with the open meeting law. If you don't establish those procedures, you probably won't have a subcommittee, and your everyday conversations with one or two council members probably do not constitute a subcommittee. Next, I want to talk about meetings. Although seemingly simplistic, as we cover the topic of meetings, please keep in mind that the definition of a meeting for the open meeting law purposes is much different than the everyday use of that term. The open meeting law defines a meeting as any gathering, either in person or through technological devices, of a quorum of members of the public body where they discuss, propose, or take legal action with respect to an action that may come before the public body. As a refresher, a quorum is the number of council members required to be present to take action, typically a majority of the council in most instances. In some instances, a supermajority of the council may be necessary for a vote, but you should still consider a quorum as 4 members of the public body. A meeting can consist of oral discussions, notes, text messaging, emailing, social media, or any combination thereof where the council's business is discussed by a quorum of its members. If there is to be a meeting of the council in any form, we are required to post notice of the meeting at least 24 hours in advance, and except in cases of emergency. And the posting needs to be on the internet and on the city's website, as well as certain designated places that the clerk handles. One of the things that is important to discuss in this video is the concept of accidental meetings. So what that means is that if you are not mindful of the open meeting law, accidental meetings can occur and result in a legal violation. For example, if several of your fellow council members are all part of the same neighborhood chat group on the internet, you could inadvertently have a meeting if the council's business is discussed through the chat group. But before you panic, please keep in mind that it will only be seen as a meeting if you are discussing the council's business. For example, discussions, deliberations, considerations, or consultations regarding issues that may foreseeably come to the council for action. If you are just talking to your fellow council members and sharing your favorite recipes, that would not be considered a meeting for open meeting law purposes. The published agenda will establish the limits of what can be discussed by the council at a properly noticed meeting. The agenda item listed should be sufficient to apprise the public of the subject of discussion, and then discussion for that agenda item must be limited to subjects reasonably related to the agenda item. If it is not related to an agenda item, it should not be discussed at the meeting. One of the pitfalls of the open meeting law and the difficulty of the definition of the meeting is the concept of serial communications. When you think of all the different forms of communication in use in modern society, Keep in mind that a meeting that is subject to the open meeting law does not have to occur at the same time and place. What I am talking about is serial communications where messages or discussions get relayed to a quorum of the members. For example, if you're on a 7-person council, if you send an email to one other council member about council business, that is probably okay. However, if one of you turns around and forwards that email to 2 other council members, you now have a quorum and a meeting. So if notice and agenda have not been published, you could be inadvertently violating the OML by forwarding these emails. And this applies to all forms of communication. If you and one other council member are texting each other about council business, and then you each agree to talk to one other council member about the same thing, you now have a quorum involved in the discussion and a potential OML concern. It is prohibited to try and skirt the requirements of the open meeting law by having an intermediary non-member relay communications. For example, Tempe City staff are advised not to relay communications between council members. So you cannot ask the staff liaison to talk to other council members and find out what they are thinking regarding an item. However, city staff can initiate a one-way communication to council members for limited purposes. For example, if a city staff member prepares a PowerPoint to present to the council at a properly noticed meeting, he or she may email that to you in advance for preparation. Typically, the PowerPoint will be posted with the agenda for the public to share. But you cannot discuss the topic with a quorum of the council members until the regular meeting occurs. You can review the PowerPoint and formulate questions that you may have, but you should wait for the discussion until the actual meeting at the noticed time and place. The easy thing to remember is that your staff liaison will be working with the commission to make sure that an agenda is created and properly published. Once the properly noticed meeting is held and an agenda item is called, the council can freely discuss that issue together and anything else reasonably related to the discussion. Now that we've covered the basic concepts of the open meeting law, I want to discuss briefly the exceptions to the open meeting law that will impact your everyday service to the city. The main exception is the executive session. Executive sessions are an exception to the requirement for open meetings in that the council can have executive sessions which are not open to the public under limited circumstances. An executive session is limited to only those members of the public body and city staff or other persons that are reasonably necessary to help the discussion. Executive sessions are limited to a list of enumerated exceptions in state law. However, we are still required to post a notice and agenda in advance of the executive session in the same manner as regular meetings. That means that the agenda for an executive session must identify the subject of the discussion, and the discussion for that item must be limited accordingly. In addition to the regular posting requirements of the open meeting law for open sessions, state law also requires that an executive session agenda also identify the specific exception to the open meeting law. For example, if the city attorney's office intended to provide confidential legal advice to the council, we may ask you to hold an executive session, and we would provide agenda language for the discussion and identify ARS 38-431.03A3 as the exception. The next slide contains the list of exceptions for executive sessions recognized by the open meeting law. You will see that with the exception of international interstate negotiations, the exceptions listed here can be commonly encountered in conducting the business of the city. But keep in mind that the executive session is strictly limited to the topic of the agenda as well as the purposes of the particular exception. Also remember that the council cannot take any legal action in an executive session, but can only provide direction to staff for a matter to be further considered on a regular council meeting agenda if legal action is desired. Executive sessions, rules, and procedures can be complicated. So this is an overview, and a more in-depth discussion for executive sessions will be provided separate from this video. Now that we have covered the open meeting law basics, I just want to mention some of the possible consequences for violation of the open meeting law. One of the primary concerns is that any action taken by the council which did not comply with the open meeting law could be null and void. In addition, the state attorney general and a county attorney can bring an action to impose civil penalties and attorney's fees. In extreme cases, a member could be removed from his or her position. Those are the main legal points, but violations of the open meeting law can cause the public to be distrustful as well. So we hope you'll find this video helpful in making sure that all of us comply with the open meeting law. Your understanding and compliance with the open meeting law is very important to the city. At the City Attorney's Office, we want to make sure that you have tools you need to protect yourself and the city from violating the open meeting law. With that said, this presentation is just the basics and does not cover all the intricacies and nuances of the OML and its related issues. Please keep in mind that the City Attorney's Office is available to you if you encounter a situation and need additional guidance or direction. Thank you.